A typical dispute resolution process involves several steps aimed at addressing and resolving the conflict or disagreement between the parties involved. While the specific details may vary depending on the nature of the dispute and the chosen method of resolution, the following outline provides a general framework for a typical dispute resolution process. Step 1. Identification of the dispute. The first step in the dispute resolution process is identifying the issue or conflict that needs to be resolved, and may involve one or more parties bringing forward a complaint, grievance, or claim regarding a particular matter or disagreement. Step 2. Initiation of the process. Once the dispute has been identified, the process of resolving it is initiated. This may involve notifying the other party or parties involved in the dispute and expressing a willingness to engage in resolving the matter through negotiation, mediation, arbitration, or other methods. Step 3. Information gathering and analysis. Before proceeding further, the parties may gather relevant information, facts, and documentation related to the dispute. This may include reviewing contracts, agreements, policies, correspondence, and other relevant materials to understand the underlying issues and interests of each party. Step 4. Communication and negotiation. This is the first step to try and solve the issue in-house, as the employee talks directly with their supervisor or manager to address the issue at its source, and open communication is key here. For example, the parties engage in direct communication and negotiation to discuss the issues, clarify concerns, and explore potential solutions. This may involve exchanging proposals, making offers, and seeking common ground to reach a mutually acceptable resolution. If the initial talk doesn't resolve the issue, the employee might involve HR. HR can offer guidance, mediate discussions, and ensure company policies are followed. For example, negotiation may be conducted directly between the parties or facilitated by a neutral third party, such as a mediator, who assists in communication, problem-solving, and reaching an agreement. Step 5. Mediation or conciliation. If the parties are unable to resolve the dispute through negotiation alone, they may choose to engage in mediation or conciliation with the assistance of a neutral third party, known as a mediator or conciliator. The mediator facilitates communication, helps parties identify underlying interests, and assists in generating options for resolution. The goal is to reach a voluntary agreement that addresses the needs and concerns of all parties involved. Step 6. Arbitration. If mediation or negotiation fails to resolve the dispute, the parties may opt for arbitration, where an impartial third party, known as an arbitrator, hears the arguments and evidence presented by both sides and makes a binding decision to resolve the dispute. An arbitrator makes a binding decision that both parties must follow, and this is more formal and expensive than mediation. Arbitration may involve formal procedures, including hearings, witness testimony, and submission of evidence, and the arbitrator's decision is final and legally binding on the parties involved. For example, if internal processes fail, either party can lodge a formal application with the Fair Work Commission, and they offer conciliation services, where a conciliator tries to guide the parties towards a solution. Step 7. Litigation. If all other methods of dispute resolution are unsuccessful or deemed unsuitable, parties may resort to litigation, where the dispute is brought before a court or other judicial body for resolution. Litigation involves formal legal proceedings, including filing of complaints, hearings, discovery, presentation of evidence, and judicial decision-making. The outcome of litigation is determined by a judge or jury, and the decision is legally binding on the parties involved. Step 8. Resolution and implementation. Once a resolution has been reached through negotiation, mediation, arbitration, or litigation, the parties may formalize the agreement in writing and implement the agreed-upon terms and conditions. Depending on the nature of the resolution, implementation may involve payment of damages, performance of obligations, modification of contracts or agreements, or other actions necessary to comply with the terms of the resolution. Step 9. Closure and follow-up. After the dispute has been resolved and the agreed-upon terms implemented, the parties may formally close the matter and follow up as needed to ensure compliance with the resolution and address any remaining issues or concerns. It's important to note that not all disputes will follow this exact process, and the steps involved may vary depending on factors such as the nature and complexity of the dispute, the preferences of the parties involved, and the chosen method of resolution. Additionally, alternative dispute resolution methods, such as negotiation, mediation, and arbitration, are often preferred over litigation due to their flexibility, efficiency, and potential for preserving relationships between the parties involved.